I guess I'm a little concerned about defendant's version and responsibility. You don't want to
It's,
elaborate.
I mean, they're, even from the state's facts, Judge, I don't think that anyone has any proof that he left with the trailer because he did not leave with the trailer. And that's been my client's issue with the case from the beginning. But I've told him that he was there. He gave whoever left with the trailer
As a part.
access. And so he is an accomplice in this case. He is not the one that took the property, but he did assist them with access. And because of that, under Texas law, that is enough in order to prove his guilt. That coupled with his history, I told him that I thought that if we went to trial, that he likely could have these issues resolved against him and not in his favor. And so with that, we would ask that the court, accept this and move forward. Whatever it's worth, if he could have come up with the full amount of restitution, the state was going to give us a much better result than what we got here. But unfortunately, money for him is just really tight. And so he's unable to come up with those funds. But the $3,000 will be paid today.
All right. So when's the last time you used them? It has. How long's a while?
I was 18, but I had some relapses since I got out. But it's been 6 months.
Let's do this. Before I go further, I'm going to get a drug test done just based on that history, and then we'll see where we go from there. Have a seat in the jury box. You want to try again on the last time you used methamphetamine?
I've struggled with daily use for a long time, Joe. So
What?
I've struggled with daily use for a long time. It's something I didn't know how to answer that question.
Judge, with his
I'm
VA status, he's a honorably discharged veteran. I was hoping maybe the court might consider requiring him to get drug treatment through the VA and perhaps consider him for super intensive probation, maybe through drug court.
Sir, stop talking over your lawyer.
Yes, ma'am.
To maybe help him with his addiction issues.
Well, here's where I am. He was already on probation in 2018 for 2 offenses, a burglary of a building and a possession of a controlled substance. Went through the veterans program, including inpatient treatment referral, was revoked on both of those and received prison. The only way I will go along with this is it's going to be safe P going into custody today. We're not taking, there's no reason, number one, on paper for him to really be eligible for probation. Your attorney's done a great job, but if you can't kick the habit, then you're going to get more than just outpatient treatment through the VA. That's already happened. So if, obviously any condition of probation is up to the court anyway. And so we can go forward at this time unless anybody has any reason not to go forward with sentencing.
I'm okay with sending on.
Okay, good.
I don't believe my client wants to proceed.
Well, so here's the thing, Mr. Street. The conditions of you've already agreed to probation. So any condition of your probation, outpatient treatment, just like Mr. Crenshaw is asking for, inpatient treatment, which apparently you don't want. Those are all actually they're up to me. And so it's not really part of the agreement, and it's not something that I'm going to allow you to withdraw your plea over, because that's up to me. Anytime you're on probation, the conditions are up to the court and probation, what they feel's best. And in your case, if you're showing up to court after having had treatment and after having had 2 felonies already revoked, testing positive for meth, this is what I feel like is best for you and for the community to keep everybody safe. So at this time, in cause number 24, DCCR 2058, I'm going to find that you entered your plea previously freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of theft of property. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. I'm going to probate that. I'm actually going to change the length.
And here's the twist. He's sentenced to 2 years, but it's probated. That means he avoids prison for now. However, the judge just extended supervision to 3 years. That's longer oversight, stricter control. This isn't freedom, it's a structured second chance. And if he slips, that 2-year sentence is already locked and loaded.
Length of time to 3 years, which is another condition that is up to the court ultimately. You will be required to pay the $6,000. Did you bring the $3,000 today? Okay, so the $3,000 was to be paid today. So that leaves $3,500 to be paid while you're on probation. As a condition of your probation, what I will do instead of safety is order that you enter and successfully complete the substance abuse track of the ISF program. It's still an inpatient in custody program, but it is a shorter one. You will be required to go through the JCDI program when you get out as your aftercare. And so if you do all of that, this is, I don't even know if you realize what a big opportunity this is today. So your case for all practical purposes here in court is over if you do everything you're supposed to do. The other side of that is if you don't do everything you're supposed to do, you're going to be back in here and you're looking at the 2-year sentence that you've already agreed to. Do you understand?
Yes.
I'm going to hand you,
Judge, he does have a family. Is there any way that before he turns himself in for ISF, he could have a week or so to get his affairs?
no, he's got, no, not with the criminal history, not showing up testing positive for methamphetamines. Those do not stay in your system that long, which means he has done them very recently.
Yeah, they know.
So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can speak with Mr. Crenshaw. Good luck to you, sir. I hope you take advantage of this.
Thank you, Your Honor.
Thank you. Thank you, Mr. Crenshaw. Good morning, sir. You Spencer Broussard?
Yes, ma'am.
And Mr. Broussard was previously in court and cause number 25 DCCR 1442, entered a plea of guilty to aggravated assault with a deadly weapon. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections?
Not from the defense, Your Honor.
Not from the state.
I guess I have a little concern because Mr. Broussard, you stated this was all just a setup, which makes me a little concerned that you're not taking responsibility for your part in what you pled guilty to. And so it's important, obviously, if you pled guilty, I asked you some specific questions. If you're pleading guilty freely and voluntarily, and if you plead guilty because you did what they charged you with.
Yes.
So did you do what they charged you with?
Yes, ma'am.
Okay. Any reason not to go forward?
No, Your Honor.
No, Your Honor. All right, then at this time, I'm going to find, Mr. Broussard, that you entered your plea of guilty previously, freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed and you'll never have a felony conviction in your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go for your paperwork. All right, good luck to you, sir.
Where facts meet emotion, justice finds its voice. To witness more real courtroom moments, subscribe to Law Nexus.